Has everyone hit their permission to begin?
Yes, Your Honor.
Yes, Your Honor.
Gotcha. All right. Good morning, everyone, and welcome to the July docket of the Kansas Court of Appeals. I'm Tom Malone. We also have Judge J.C. Hurst and Judge Angela Coble. We are the panel for this morning's hearings. I want to thank counsel for participating in the hearings this morning by Zoom. Without going into much detail, I'll just say that we recently had some COVID exposure on our court, and we just decided at the last minute that it would be better and safer for everyone if we did the hearings this morning by Zoom. So I do want to thank counsel for that. I know we have experienced counsel, so let's just jump right into the first hearing. It is from Sedgwick County. It is case number 126636, entitled The State of Kansas versus George Eugene Phillips, Jr. We have Matt Maloney for the state and Casper Shire for Mr. Phillips. Mr. Shire, as the appellant, will begin with you. And first, let us know, do you wish to reserve any time for rebuttal?
Yes, please, Your Honor. Could I have 3 minutes?
That is granted, and you may begin whenever you're ready.
May it please the court, again, I'm Casper Shire, appearing for George Phillips. George Phillips got into an argument with his ex-wife in ex-wife's car in a Wichita fast food parking lot. George and his ex-wife offered conflicting testimony about what happened in that parking lot, but based on ex-wife's testimony and based on minor cuts and scrapes, the state elected to pursue a level 1 aggravated kidnapping charge against George. George's jury took 3 days of deliberations to return a guilty verdict on that charge. George has raised sufficiency issues, instructional issues, and prosecutorial error issues for this court. And like another case considered by this very panel, State v. Riley Moore, many of those issues are rooted in the case law definition of bodily harm that relates to an aggravated kidnapping charge.
I was going to ask, do we have some deja vu going on here?
I thought about doing a deja vu all over again. I decided everyone here probably was pretty aware of the similarities between those two cases. Yes.
The five of us got together on a hearing eerily similar about a year ago, at least in terms of the legal issues. But unfortunately, the Moore case, we don't have final resolution. It's still being reviewed, correct?
That's right, Your Honor. What I will say about the Moore case is I expect one of two things to happen because this court never reached the question of clear error and whether or not failing to instruct a jury on the definition of bodily harm in a case like this one is clear error. So I expect either that Moore is going to come back to this court to answer that question squarely because I think it needs to be answered. Or frankly, we argued to the Supreme Court that it was clear error and they should affirm this court as, you know, reaching the right outcome on a different analytical path. So
we relied on cumulative error, and then the case law has changed a little bit on that since then, correct?
That's right. Yes, the goalposts have moved a little bit, and I think the way this court analyzed it, frankly, was spot on, given the case law that existed at the time. Since then, we've had State v. Waldschmidt, which essentially says 2 unpreserved instructional errors do not get cumulative error review, which does change the reversibility standard. And obviously, we're not here to argue about the Moore case today. We're here to argue about George's case. But first and foremost, on that instructional error, what we are arguing is that it's the same error. And since this court found error in Moore, it should find error too here as well. And second, that it is clear error under the facts of this particular case. And I'll point to 4 things in the record that I think emphasize that. The first, and this is going to apply to any case where the evidence of bodily harm is thin. And again, we renew our argument that the evidence here is not just thin, it's insufficient. But if it is sufficient, it's minimally sufficient. And in a case like this, having that definition, the jury didn't know that trivial injuries likely to result from any forceful kidnapping by the very nature of the act are not bodily harm for aggravated kidnapping purposes. And not knowing that has an outsized impact on verdicts in cases like this one. Second, not only did the jury did not know that definition of bodily harm for the purposes of aggravated kidnapping, they were actively misinformed. The state argued in closing, quote, "The injuries don't have to be huge, just injury to the body. That's it," end quote. That is not the definition that applies to this case. That's not the definition that's in PIC. It has to be more than bodily harm that is part and parcel of the act of kidnapping. And since the jury not only didn't know that, but actively was told something else, this court should be firmly convinced that the verdict would have been different absent this error. Third, I mentioned this already, but the jury deliberated on this charge for 3 days. And we know that it was this charge that they were wrestling with, because if you look at their verdict form, they dated when they reached each verdict. So we know that on the first day of deliberations, they convicted on criminal threats, aggravated assault, aggravated battery. We know that on the second day of deliberations, they acquitted on ag assault of a Leo. And we know that it wasn't until the third day of deliberations that they actually returned a guilty verdict on aggravated kidnapping. So this is something that they were struggling with to the very end. And this court should be firmly convinced that an instruction on bodily harm would have made the difference. Finally, I'll just point out the greater context of this case. This was not even an aggravated kidnapping case or a kidnapping case to start with. This became a kidnapping case after the prelim evidence because George would not plead as charged. That was the hammer that the state wanted to use against him in this case. And they did. But the point I'm trying to make here is that this was not an obvious kidnapping, let alone an obvious aggravated kidnapping. And in cases like that, this instruction absolutely could have and would have made the difference. Unless this court has other questions on that particular instructional issue, I'd like to touch briefly on the failure to instruct on simple assault and simple battery as well. And here, our argument on the merits is essentially that Lowe controls the outcome here. This was error. If the evidence is sufficient for aggravated battery and or aggravated assault, it's legally and factually appropriate to give the lesser as well. And this is a case where this court should be firmly convinced that the jury might have elected the middle option on both of these charges.
Didn't you at least invite the error on the simple battery? If there was error?
No, Your Honor, I don't think defense counsel did.
I thought he said flat out, I don't want an instruction on simple battery. Maybe I'm wrong.
That's not my memory of the record. My memory of the record is that counsel said, I don't think our defense supports a lesser on aggravated battery, a lesser on simple battery, which is different. No, Your Honor, I don't. I think that's different from when we're talking about invited error. The phrases that I see popping up in the case law over and over again are phrases like actively pursue an affirmative request. And I think there's a significant difference between saying, gosh, I don't think our theory of the case here supports a lesser on simple battery, and saying, I do not want you to instruct on simple battery. The first is a legal mistake. It's wrong. It's not trial strategy. It's inadvertence. And it's not inviting the error. It's acquiescing to it. Because if my memory is right, and again, the record will speak for itself here, but if my memory is right, the court addressed counsel and said, well, I don't think your theory here is that this didn't happen. I don't think a lesser is appropriate. And defense counsel essentially agreed with that. So I think that's different from inviting the error. But anyway, as to the aggravated assault charge, there was no discussion, as far as I can remember, about whether or not it was legally factually appropriate or whether or not it should be given.
You've now used, no, I'm sorry, I miscalculated the time. You're not, you still have additional time. I'm sorry.
Okay, thank you, Your Honor. I've hit a lot of the things that I hope to hit.
I'd be interested in your argument regarding the injury to the victim and the sufficiency of the injury.
Sure. And this is another area where I think the goalposts have moved a little bit since I originally briefed this, particularly with the Garcia-Martinez case, which says that taking and confining are no longer alternative means. I think it's fair to say that everyone at the trial here thought they were. In fact, there was one section in the record where the prosecutor actually said, this is an alternative means theory. I know it's going to be subject to super sufficiency, but this is the theory that I want to present. So given changes in the case law, I mean, it's not alternative means anymore. This was perhaps a multiple acts issue and not an alternative means issue. Was the taking outside the car or was the confining inside the car? I guess I apologize because I've gone off on kind of a tangent that doesn't answer your question at all, but I think it's part of the backstory here. I think at the end of the day, no matter how you look at the evidence, there has to be a floor for what level of harm is good enough to take an aggravated kidnapping charge to a jury. It has to be more than what is just trivial injuries, part and parcel of a forceful kidnapping. We don't believe the evidence here clears that. I'll concede it's not a terribly high bar, but I think the injuries here speak for themselves. They are scratches. They are scrapes. We are talking about a level 1 offense that subjected George to over 600 months of incarceration. This is not the type of injury that rises to the level that a jury should even, that the question of bodily harm should even go to the jury in a case like this, Your Honor.
Now, the injuries they occurred with the use of a screwdriver, though. Is that right?
That was ex-wife's allegation, yes.
Does that make a difference?
No. And I think what this court might be asking about, and I know the state has argued this, that there's a, if you look at State v. Royal, which of course is one of the cases that we rely on for the proposition that the jury should be instructed on bodily harm. The Royal case also said, well, injuries inflicted by a knife or a firearm are bodily harm as a matter of law. A screwdriver is not a knife or a firearm.
But wouldn't you say that the screwdriver was utilized in a manner similar to a knife? I mean, how do you parse the difference there?
To be honest with this court, I don't think this court does. I think if the court is, and I know the state has made arguments that Royal should be overruled. I know the state has also made arguments that that particular exception in Royal should be expanded to include the facts of this case. I think those are both arguments that with all due respect to this court, need to be made to the Supreme Court. I think Royal is what it is, and this court has to apply it as it's written. And it's a knife or firearm exception, not some sort of dangerous weapon exception.
All right, counsel, you've now used, unless there's any other questions, you've used 12 minutes. So if you still want your rebuttal time, we'll switch over to Mr. Maloney.
Yes, I'll save any remaining thoughts for rebuttal. Thank you, Your Honor.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. And to begin with, just straight up, I'll acknowledge, obviously, that unless and until the Supreme Court overturns the Royal line of cases in Moore, then clearly I acknowledge that as of right now, this court is bound to continue following Royal. But I did feel like it was important to point out in the brief that when Moore was argued to the Supreme Court about 3.5 months ago, that a great deal of attention was focused on whether that exception requiring that the injuries be more than trivial or slight is going to actually stay in place. The court certainly indicated that, in at least some of the justices' opinion, that was a judicially created law that is inconsistent with the statutory language. And so clearly, if the Supreme Court does render a decision in Moore before this case is decided, then that could in fact be dispositive on that issue. But as of right now, clearly we would acknowledge that this court is continued to be, is still bound by Royal.
Sorry to interrupt, counsel. Though there should be some difference between kidnapping and aggravated kidnapping, right? I mean, the consequences are remarkably different. So shouldn't there be a difference in the occurrence of the events and the harm to the victim?
I agree, but I think that even just reading the statute literally, it does require bodily harm. That's the difference. And I think the question is, well, does bodily harm mean that it has to be something more than trivial or slight injuries? And if you just read the statutory language, it does not say that the injuries have to rise to a certain level. And so I think even if the Supreme Court were to overturn Royal, that would be justified based on a strict reading of the statute. Because I think in order to get to Royal and the cases that followed, there was reading language into the statute that doesn't exist. And I think that was where, during the Moore oral argument at the Supreme Court, that was where the questions came from, was what is the basis for that decision in Royal saying that it has to be more than trivial or slight when the statute itself does not require any such, there's no such limitation in the statute. But
so was it in the state's contention that sort of any bodily harm, like you kidnap someone and they twist their ankle, that would be aggravated kidnapping?
I do feel like reading based on the statute, yes, I would argue that that does constitute, that does make it an aggravated kidnapping in that situation. That if you forcibly kidnap somebody, it clearly is not unforeseen or unforeseeable that in the process, if you're using physical force, that they might in fact suffer some sort of a bodily harm. And I don't feel like it's inappropriate or unfair to a defendant to then subject them to greater penalties and a greater severity level if they have chosen to use force to effectuate a kidnapping, and in the process the victim does suffer some degree of bodily harm, whether that be in the form of a sprained ankle or if you push them to the ground. And I know a large focus during the Moore argument was, well, how would you ever have a forcible kidnapping then that doesn't rise to the level of an aggravated kidnapping? And I'll reuse some of the examples that I gave at the Supreme Court argument and Moore. You very clearly can have a situation where somebody just physically takes hold of the victim. And let's talk about, for the example of Moore, let's say
counsel, I'm sorry, let me interrupt and just ask you some very basic questions about this case. And I apologize for not having reviewed the record as well as I should. So my questions here are very basic. But in our case here with Mr. Phillips, according to the state's theory of the charges, my first question is, when did the kidnapping occur in this case? When did the taking occur that constitutes the kidnapping charge?
I want to follow up on that because you mentioned, that the harm could occur in the process of the kidnapping. So I think the statutory language is that the harm needs to occur after, correct? So along with Judge Malone's question, when did the taking occur and when did the injury occur? Because I think that's important.
Right, yes, and I appreciate those questions. And yes, the state made very clear in the way that it argued the case that the taking occurred the second time that the victim exited the vehicle in the parking lot, when the defendant then again chased her around the car, and this was the occasion where he then put the screwdriver to her throat and actually or to her neck and actually did end up stabbing her the 5 times.
I'm sorry, I thought that occurred in the car.
No, that was outside the car. That was outside the car. The second time that she got out, he chased her. He pulled the screwdriver, held it to her, and then stabbed her 5 times, I think once near the throat and 4 times in the side. And the state was very clear to say that we were not alleging that the taking occurred the first time that she exited the vehicle and then she got back in the car. It was very clearly argued that the taking occurred the second time she got out. He immediately got back out of the vehicle, chased her around the car, produced the screwdriver, and then stabbed her 5 times. And so the state very clearly specified that was what we were relying on for evidence of the taking. And that was when those injuries were inflicted. That was right at the time that he did that. And so that was the evidence that we relied on for the taking. And then we clarified further that we were arguing that the confining was then after she was back in the car the next time, and he got behind her in the rear driver's seat initially, and he continued to hold the screwdriver to her. And then after he got back in the front passenger seat, that was when he wrapped his legs around her and prevented her from exiting the vehicle. And it was only after the police officer was able to help free her that she ended up falling. But that was when she then suffered additional injury, when she had to be dragged out of the car and ended up falling onto the pavement. And at that point, she then injured her elbow. So those were, and as counsel indicated, we now know that these are not alternative means, but as we were proceeding at the time, we specified that which was the taking and which was the confining.
Now, the leg wrapping occurred though when officers were there, correct?
Yes. As they were approaching the car, both officers testified that they could see that his legs were wrapped around her, preventing her from exiting, and the body camera footage also shows that. And of course, the defendant's testimony was contrary. He claimed that not only was he not trying to keep her in the car, but that he was actually trying to kick her out of the vehicle so that he could then essentially take the car and drive off. And so, yeah, we had the 2 officers testifying what they saw with their own eyes, and then we had the body camera footage. And I do want to emphasize, because I think that in some of the technical legal arguments here, it might get overlooked. The theory of defense here was that he never had the screwdriver. He claimed that he not only never used it that night, but he claimed that he didn't even know it was in the vehicle, and he was mystified as to how it was even there when the officers ended up finding it after the incident was over. And so this was not a case. And I understand that when you're looking at instructions, that the district court's job is to instruct based on the evidence. But we can't forget here, when we're looking at whether this instruction was necessary, and especially whether certain instructions were reversible error, that this was simply not a case that, as it was presented to the district court, focused on the extent of the injuries. It focused on whether you believe, in all honesty, it came down to a credibility contest. He was arguing flat out, I did not do any of these things that are alleged. I didn't have a screwdriver. These injuries that she suffered did not come from a screwdriver. I think he essentially tried to argue that, well, the only thing that happened to her was when I think he used the word dove, that she dove out of the vehicle at the end of the incident, and that was the only time that she suffered any type of injuries to her body.
Do you
And
agree that the injuries from her escaping are not part of the injuries attributable to the aggravated kidnapping?
I don't, because I think those were part and parcel with the confining. When he was confining her in the vehicle by wrapping his legs around her, that is what prevented her from exiting the vehicle of her own volition. And it was
So
then,
let me ask this. If she dove out of the vehicle from fear, from just fear, they weren't touching each other at all when she dove out and she scraped her elbow, is that an injury for aggravated kidnapping?
if he had not done anything to keep her in the vehicle at that
I mean,
point,
other than scare the living daylights out of her, threaten her children, threaten her life. I mean, let's not say nothing.
right,
She's mortified, she's scared, and she dives out of the car and scrapes her elbow.
that's definitely a closer call. Looking at the statute, it defines kidnapping as taking or confining accomplished by force, threat, or deception. So if there hasn't been any specific force, and if he hasn't threatened her or deceived her, then I think that I don't want to concede that that would not be
No, aggravated kidnapping. Sorry, I'm not saying it's not kidnapping.
right, right. But I think there'd be a real question, I think, to some level of um, whether he would even be confining her at that point if he hasn't used force or threat. But fortunately, in this case for the state, well, two things. One, because we now know that these are not alternative means, we don't have to prove both taking and confining. And as I indicated before, the evidence of the taking was overwhelming, that he chased her around the car, held her with the
Yeah,
screwdriver,
I'm
and then
fine with
used.
that. I'm concerned with the difference between kidnapping and aggravated kidnapping, and how we get there is the injury,
Right.
right?
And
Bodily
again,
harm.
yeah, and again, for the taking, the injuries were absolutely at the same time that he effectuated the taking. He
And
produced
isn't that a problem for the state?
Problem.
Because, I mean, if we're looking at Royal, it says we're looking at those injuries that occur after the initial abduction. And if we're talking about the injuries occurring at the same time as the taking, isn't that a problem?
well, he produced the way, I mean, he chased her around the car and then caught up to her and grabbed her. And then is when he used the screwdriver to inflict the injuries. So I've been loosely using the phrase at the same time, but obviously in order to inflict those injuries, he had to first catch her as she was running around the car trying to get away. And he did that. She had gotten out of the car, but then was unable to get away because he caught up with her quite quickly. And then once he caught her, and obviously was close enough that he was right there beside her, if not already touching her, and then he produced the weapon and inflicted the injuries. And so I think even reading it to say that it has to be after the abduction, I think that's satisfied in this case, because clearly he wouldn't be able to inflict stab wounds if he had not caught up to her and already accomplished the abduction.
So
At
you're
that,
saying it's impossible for someone to have physical injuries prior to being actually kidnapped?
Not impossible. I mean, obviously, if you were to shoot somebody from, if she had escaped and gotten 30 yards away from her, and then he fires a gun at her, and injures her at that point, then obviously that's a different situation than where he's already caught up with her, is holding her at knife or screwdriver point and then inflicts the injury. So there could be some scenarios where you could say that, okay, this person had already been injured before he or she had been abducted or taken or confined, and then the kidnapping happened after the injuries. But that's not what happened here. This was something where, again, she got out of the car, was temporarily free from his physical grasp, but then very quickly he did catch up with her and inflict the injuries, and then led her back into the vehicle. As to getting back to Royal,
Well,
even if,
counsel, you've actually used 15 minutes, so you'll need to start wrapping up your overall argument.
right, yeah, and that's what I plan to do. Even if the Moore court does not overturn Royal, in this case, the evidence was that these were injuries that were inflicted with a screwdriver, and that distinguishes it from Moore, where there was no weapon used. And counsel is correct that in Royal, we were talking about an actual knife, and that the holding and Moore specifically said if it's a gun or a knife. But this court obviously can use common sense in interpreting that opinion. And I think the purpose of it is to distinguish situations where somebody injures a victim with the use of a weapon. And here what you have is a screwdriver was very clearly used in the same manner that a knife would or could be used. And so I don't think we need to split hairs as far as saying, well, was this something that was actually designed as a knife, or is it simply something that was used as a weapon? I would make the same argument if he had used a baseball bat to inflict injuries on her and she had suffered injuries as a result of that. Those simply are not the types of things that are part and parcel and likely to result from any forcible kidnapping. So that's why even if Royal continues to be the state of the law, the state's position is that the injuries inflicted here constituted bodily harm as a matter of law, and therefore not only was the evidence sufficient, but there was no need to issue the instruction defining bodily harm on these facts.
All right. Yes, go ahead.
Sorry, Judge Malone. This really quick. Do you think we need to wait for more for this, Maloney?
I don't think you would need to, because I think that the state should prevail for the reasons I just articulated, even if Royal is not overturned. I certainly wouldn't have any issue with you, because clearly Moore is going to give important guidance. And at the very least, it might inform the rationale that this court should follow in deciding this case. And so if, for that reason, I think it would certainly make sense to do so. And it was, I think, 3.5 months ago that we argued Moore, and so I would think, not trying to anticipate the Supreme Court schedule, but I would think that opinion is not too far down the road. So I think there's no harm that could come with waiting to see exactly how the Supreme Court decides to handle that case.
And I don't know, Judge Malone, if it's okay with you if I get Casper's opinion on that question as well before you start running this time.
Sure.
Because he might have a different view on that.
I guess I would have the same view for different reasons. I agree that this court could resolve it right now, because I think, first of all, the question of whether or not particularly the instructional error in not instructing on bodily harm, that wasn't one of the issues in front of the court. So it's error. All this court needs to do is decide whether or not it's clear error. And frankly, in Moore, the question of whether Royal is still good law was never briefed. It was never presented to the justices before argument. It did come up at argument. We did talk about it, but I don't think it was squarely before the court. And, you know, I hesitate to predict what Supreme Court decisions are going to look like, but I don't think that the court is in a position to overrule Royal in Moore. That's my position.
All right, and you still have your 3 minutes of rebuttal, Mr. Shire?
Thank you, Your Honor. And I'm going to try to make 3 quick points if I can. First, I agree that the scratches on ex-wife's chest were the bodily harm. And in fact, that's exactly what the state argued in closing. I'm looking at volume 6, page 95. The state argued bodily harm was inflicted upon Mona Phillips. I'm skipping a few lines. So what about her injuries? State's exhibit number 4, she's got injuries. State's exhibit number 4 is the injuries on the chest, which were purportedly caused by a screwdriver. So that is the injury that we're talking about. And it was the act of kidnapping, as Mona described it, that caused those injuries. Second,
I'm sorry, but wasn't there also an exhibit at trial showing a wound to her side?
Yes, that was a separate exhibit. It's my understanding that all of those came at the same time. Different parts of the body, but all together was my reading of that. But at any rate, the injuries they elected are the injuries in exhibit 4. And I think I dropped exhibit 4 in my brief as well. So, and it's obviously part of the record. So I think those are the injuries we're talking about. Second, George does not need to run a guilt-based defense in order to get the benefit of a bodily harm instruction. They're different defenses, as the state is arguing, absolutely. But they're not inconsistent defenses in the sense of, I have an alibi, but if you don't believe that, it was self-defense. George contested what happened in the parking lot, absolutely. But whether or not the harm that Mona suffered rises to the level of bodily harm is a completely different question that I don't think has anything to do with which party you believe or don't believe there. And third, there has to be a difference between aggravated kidnapping and simple kidnapping. If all we're doing is looking at bodily harm is defined as any touching of the victim against the victim's will with physical force in an intentional, hostile, or aggravated manner. That's it. That's going to be virtually all, if not all, simple kidnappings. And if that's all it takes to aggravate a kidnapping to a level 1 offense, which carries a 600-month prison sentence if you're an A-box instead of a 200-some-month prison sentence, then we've essentially judicially written out the lesser included offense of simple kidnapping. That can't be the case, and juries need to be instructed that there is a difference that they need to be going back to the jury room and weighing. They spent 3 days weighing that charge without this instruction, and this court should be firmly convinced that if they had had it, this case would have come out differently.
All right, counsel, thank you very much for your excellent briefs and your arguments in this case. We'll get a decision out to you as soon as we can. If it takes a while, you may assume that we are waiting for guidance on the Moore decision. And so again, thank you very much. And that concludes this hearing.
Thank you, Your Honor.
Your Honors.